The next form is the actual petition for divorce, the petition for dissolution of a non-covenant marriage with children. Again, check to make sure that you have the form that says "with children" on it. The petition lets the judge know everything he or she needs to know about you, your spouse, your marriage, your children, and the property that needs to be divided. Fill out all of the requested information and don't leave any blank lines. Wherever you see petitioner, include information about yourself. Whenever you see respondent, include information about your spouse. Some of the information that you need to provide in the petition is the same as what we went over in the beginning. For example, number 3 asks about the type of marriage you have, non-covenant or covenant, and number 4 asks about the 90-day Arizona residency requirement. Question 6 is where you provide the court with information about your children under the age of 18. If you don't have any children with the respondent who are under the age of 18 and neither of you is pregnant, then stop and use the petition for divorce without children. And if you don't have children under 18 but you're pregnant or your spouse is pregnant, you will want to complete the question number 7 of the petition titled Pregnancy and Paternity. Questions number 8, A and B are for telling the judge about your property so the judge can decide how it should be divided. Community property is generally property that was acquired during the course of your marriage. Separate property is property that you have or that your spouse has that the other party does not have right to. If you aren't sure whether certain items are considered community property or separate property, talk to an attorney. Describe all of the property by including addresses, intersections, dimensions, colors, identification numbers, makes, models, serial numbers, and all information that specifically identifies the exact property you are referring to. And if you aren't sure of the value, you can estimate it, but make sure you can explain how you came up with your estimate. The next set of questions, 9A and 9B, are where you inform the judge about any debts you have shared, as in community debts, or individual as in separate debts in 9B. Community debts might include debts that were incurred during your marriage, and separate debts might be debts that you had prior to your marriage. In all cases, describe the debts, account numbers, bank, lien holders, etc., and check the appropriate boxes. If you have any questions, seek help from an attorney. Question 10 is about how your taxes will be handled. Read carefully and check the box only if you want to handle your taxes in the way that is described. Choose carefully because you don't want to make a time-consuming and expensive decision. You can contact the Internal Revenue Service or an attorney before finalizing your decision on number 10. If you are requesting spousal maintenance, commonly known as alimony, read number 11 very carefully. If you don't think alimony arrangements will be necessary, check the first box and move on. Otherwise, if you feel that you or your spouse is entitled to alimony, check the box to show which one of you should receive it, and then check the boxes that follow to tell the judge why you feel the court should make an award of alimony. The next question is for other statements to the court. Under Arizona law, the court has to find that a marriage is irretrievably broken with no reasonable prospect for reconciliation. Check the boxes here to confirm you believe there is no chance of you and your spouse getting back together, that you really want a divorce, and to say that it is the right court for your divorce. An example of where it would not be the right court would be if you or your spouse already has an existing court order regarding your divorce in another state, country, etc. What used to be known as custody is known in Arizona as legal decision-making. The Arizona revised statutes define legal decision-making as the legal right and responsibility to make all non-emergency legal decisions for a child, including those regarding education, healthcare, religious training, and personal care decisions according to 25-4013. If you and your spouse have an agreement in writing and signed by both of you that deals with legal decision-making authority, check both boxes in number 13 and attach a copy of that agreement to your petition. The next section includes information that is a recap of what you have completed thus far. But take a look at the first few sections, B, C, and D. They are where you tell the court what your names will be after the divorce is finalized. For example, will your children keep your spouse's name or your name? Section D is for legal decision-making and visitation requests. and Section G is for those who will be claiming the children for tax purposes. Once again, any questions on what you should do have to be directed to an attorney and/or the Internal Revenue Service. The notice regarding child support forms and the parent's worksheet for child support amount is a separate document that explains the Arizona State Parents Worksheet requirement. It tells you where to download the worksheet and how to access a free online child support calculator. The worksheet itself is a separate document, and it is necessary because it gives the judge information about your finances so the judge can decide on how to handle child support. The worksheet has to be filled out and submitted even if you agree to no child support. However, if you both agree on the money that will be used to determine the child support amount that will be paid, you can submit a joint parents worksheet. Next up is the notice regarding creditors. This form is required by Arizona law, and it explains that even if a judge orders that certain debts are to be paid by a certain spouse, the order is binding only on the spouses but not the creditors. Attached to the notice is a request for account information from creditors. You can send it directly to each of your creditors to find out specific information about any debt or debts you may have so you know what you're up against. The next form is called the Notice of Your Rights about Health Insurance Coverage. It explains your rights to insurance coverage at the conclusion of the divorce and how your children's coverage may be affected, and what steps you may have to take to avoid any lapse in coverage. The final two forms are the Notice of Requirement to attend co-parenting class and the Affidavit regarding minor children. All divorce cases are referred to the Conciliation Court Services and Mediation Center because children are involved, and you and your spouse will have to attend a co-parenting class. There is a $50 fee for the class, but the petitioner will already have paid their $50 fee as part of their entire divorce filing fee. The respondent will have to pay the $50 fee on their own and need to do so at the clerk's office. The class is mandatory, which means you have to attend. You can contact the Mediation Center for more information about the class by calling 928-753-0795. You won't be scheduled for any classes until you file proof that you formally served your spouse with the divorce paperwork we are reviewing right now. The affidavit regarding minor children is where you describe your children who are under the age of 18. Their names, birth dates, addresses, etc. have to be on this form. If there are any other open cases relating to legal decision-making or custody in any other state or countries, you have to include information about those cases in question number 4. If you don't, your case may face a serious delay or even dismissal. Lying to the court usually doesn't go over well, so do your best to make sure that you verify all of your information you provide and just be truthful. You must sign your petition for dissolution of marriage in front of a notary. If you prefer, the clerk at the courthouse can notarize your documents when you file them. Just bring the formal picture identification with you. This includes a valid driver's license, state-issued ID, or a passport. There are others, but if you don't have one of the 3 just mentioned, you can call the clerk's office ahead to find out what will be accepted. After you have completed all of your documents, make 2 copies of everything and give the original and both copies of your documents to the front counter clerk along with the necessary filing fee. The clerk will file the originals and file stamp the copies. The court is going to keep your original documents, then give you 1 copy back that you need to serve on the other party. The 3rd final copy is for your records. You can file your documents by mail if it's more convenient, but if you mail them, make sure they are notarized and include a self-addressed, stamped envelope so the court can mail you your copies after your case is assigned a case number. Remember that the clerk's office will not be able to provide you with any guidance on what you should do or what course of action is in your best interest. We will, however, be happy to provide you with information on what documents to file once you have made the decision. We can also provide you with information on filing fees, filing time limits, and other procedural questions. But if you have questions about what you should do to protect your own interests, consult an attorney. After completing all of the necessary documentation, paying the filing fees, and arranging for your service on your spouse, you will have completed step 1 of the divorce process.